Hi everyone, welcome to episode 12 of Fridays with FEMA. This is Ashish.
Hi, I'm Janisha.
So today we are continuing the discussion of non-debt instrument rules, uh, and we are going to dive into very interesting 2518 deferred consideration rules. Now, what does 25 stand for? What does 18 stand for? I think let's ask Janisha and take it forward
Sure.
from there.
Okay, so the deferred consideration construct under the NDI rules was introduced to facilitate cross-border transactions in the M&A context. It's very common when there is an M&A deal happening between a resident and a non-resident for working capital net debt adjustments to happen. There can be an earn-out component, or for other commercial reasons, a part of the consideration might want to be deferred as a part of the deal. So in order to facilitate M&A transactions, the NDI rules had introduced. Actually, it was introduced even before that, but I mean, the NDI rules continue with the construct of deferred consideration. So, whenever there is a transaction where the shares of an Indian company are being traded between a resident and a non-resident, the buyer can defer up to a maximum of 25% of the total consideration, but only for a period of 18 months. And 18 months is computed from the date of signing of the share purchase agreement, not closing. So that's one point to be considered. This buyer may be a resident or a non-resident. So let's take an example of a seller of an Indian company who's selling his shares in the Indian company to a non-resident buyer. The non-resident buyer can withhold to up to 25% of the total consideration for a period of 18 months. When the within the 18-month period, either that consideration that's withheld is given back in whole or part to the seller, or if it is not given back, then it's not remitted to the seller, then whatever 75% of the consideration that was paid to the seller, at least that should be in compliance with the pricing guidelines. So in my example, since the seller is a resident, the 75% consideration received by the seller should be at or above the fair market value determined at the time of transfer. So this is largely the deferred consideration rule, or the 25% and 18 months point that Ashish had raised. That's point one. This money, this deferred amount, can also be kept in an escrow account. That's also something that is permissible.
Sure, sure.
So, Ashish, let's talk about how the adjustments would typically happen. As I said, in an M&A context, there are a lot of there are deals where there could be a net debt working capital adjustment that would happen post closing, and hence there would always be an adjustment to the consideration amount. There could be an earn-out component. So, how would typically an adjustment happen, especially when the seller has been paid some amounts?
Okay, sure. So I think let's divide that into two parts,
Hmm.
right? I think firstly, I think adjustments the deferred consideration could be both upward as well as downward. All right, I'll give you an example. Let's assume that we were the total considered the max consideration payable was, let's assume, 100, right? Now, in if you're applying the 2518 rule, then 25% of this, which is 25 rupees, could be deferred,
Hmm.
which means 75 could be paid upfront on the date of closing, and the balance amount of 25% had to come within the 18-month period from the date of execution of the SPA,
Correct.
right? So this is a straightforward rule, and then within the 18-month period, whatever your net debt calculation, working capital calculation was, you paid that within the 25 amount. You paid 10, 15, 5, 25, whatever it is, right?
So just to clarify, so let's say if your pre-closing net debt working capital was largely similar to the post-closing, and there's no adjustment to be done, then you would get the entire 25 that was
Correct.
withheld out to the seller, or as Ashish said, within the 25 you could get 5, 10, 15, 20,
Yeah,
whatever
absolutely.
it is
Whatever
you
is the
could,
calculation.
whatever is the calculation.
Yeah.
Correct.
Now let's take a situation where the calculations are different. So now at the time of closing, instead of 75, the payment made was about 85. All right.
Okay. So only
Now,
10 rupees out
fif-
of 20, only 15 rupees out of 25 has been
deferred,
deferred.
right? So now you're still within the 25% rule because now only 15% has been deferred. Now, within this 18-month period, you need to either pay off the 15 that you have now, but in a situation, and that situation we already spoke about in the earlier example. Now let's take a situation where this is going for a downward adjustment, which means that your net debt or your working capital calculation has resulted in you getting a consideration of less than 85 within the 18-month period. If you're if you are going to get only 70 or 75, if you're going to get 75 or 80, then you would have to technically return that money back to the buyer, to the amount of such that 75% is with you and 25% is deferred. So in the example I gave, 85 was paid out to me
on closing.
For a max consideration of 100, which means
Right.
25 could be deferred.
Correct.
And therefore 10 have to be returned back, depending of course on the calculations. Up to 10 can be returned back depending on the calculations that are done, and 75 remains with you, and 10 has to be returned depending on the calculation. So the point that I'm trying to get at is that even a downward adjustment where you have to pay the amounts is perfectly permissible, provided it is within the 25% 25% 18-month rule.
Correct. And Ashish, you make a very interesting point. And again, just to sum it up, till the time, so it's a case where the seller has been upfront paid more amount.
Yes.
Less than 25% has been deferred. But because of the adjustments, it's been determined that, and within the 18-month period, it's been determined that the seller needs to return some amounts back to the buyer till the time that the total amount returned does not exceed 25%.
Correct.
We should be good, is what we're talking about. And fully agree with you that that should be permissible.
Right.
But what is interesting is, if you see how the NDI rules have been worded in this regard, it assumes only three scenarios, right? It assumes that the buyer is either withholding up to 25%. It assumes that this withheld amount is either put in an escrow, or the third scenario is the seller has been paid the entire amount and is returning up to 25% back in a situation like what you just spelled out, but pursuant to an indemnity. Right? Not really a post-closing adjustment or an earn-out or something similar on that front, right? So technically, and again, basis some of the practical matters where we've come across a situation, it's very interesting to also keep in mind that a lot of banks are looking at this differently, right? While in substance, this should perfectly be permissible, as we were discussing, but in practice, because of how the NDA rules are worded, some might say that you need to the seller can only return something pursuant to an indemnity claim, and yeah, so
No,
also
I think if
differs
I have
from
to, if I have to
bank.
just go into the root, or the fundamental of this 70 or 2518, right? If you think about it, the law says that you need to pay more than the fair market value upfront, which means
Correct.
technically you would have received more than the FMV
Correct.
when you were paid the 75. So therefore, from a pure legal perspective,
Absolutely.
there is absolutely no loss that is taking place.
Absolutely.
Yeah, to the revenue, to the RBI, to India as such, right? When the money,
Correct,
foreign inflows are coming in. So therefore, even if that money had to be returned to the extent it is within the 25%,
and
I think
the
it should be
total
fair.
considerations above the FMV, it should be fair. No, absolutely. So substantively, from a legal perspective, this should not be a problem, because
Correct.
I think, as you elaborated, the intent of the law is also being respected,
Yes.
right? But having said that, I'm aware that some banks do look at this differently. They're
Right.
looking at this very strictly, that a seller can literally return the funds only pursuant to an indemnity claim.
Yeah.
So I think always useful to double check also, because if the seller bank is not going to cooperate on this front or does not agree with your view, you should know that sooner than later.
That's right.
So yeah,
Sure. I think yeah, that's about the 2518.
Yeah.
But I think one other point which you touched upon very briefly right now was about indemnity, right?
Yeah.
So indemnity payments are allowed to be made under this 2518 rule, right? Which means
up to 25% of the consideration can
but
be paid.
what if the consideration is what if the indemnity amount is more? What do you do in that situation?
So a lot of times in the documents we talk about parties exploring a mutually acceptable legal structure, and one of the common ways to do it is if the non-resident has an Indian party, right? Any other indemnity payouts can be made to the Indian party. Otherwise, you need to make a case to make any other indemnity payments. You need to make a very strong case of how that indemnity payment is not linked to the transfer of your shares, right? And which can be a hard one to justify. So I think, while the permissibility of indemnity up to 25% was welcome, the concern remains that how do we really go about it if it exceeds 25%, in which case I think the examples or the ways that I suggested is what I can think of in that context.
No, sure, absolutely. I think the only one point I'd like to add here is because I told that we'll divide the discussion into two parts, right?
Yeah.
So we spoke about the first part where the deferred consideration is taking place by the 2518
Hmm.
route, right? Now, so just to clarify that the deferred consideration is taking place when the deferring is taking place for a sale of shares,
That's right.
right? So, like you said, an earnout could be either structured as a sale of shares or it could also be as a payment that is made to the
Indemnity, you mean?
no, the earnout amount. It could be either as a sale of shares or it could be structured as a bonus payment that is
Yeah,
being
that's
made to
right.
the
That's right.
promoter founder, right?
That's right.
Now, in that situation, would the latter also have to fall within the 2518 criteria? So, to my mind, the answer is no, because only
Yeah,
if
of
it is a
course.
sale of
Absolutely.
shares does a deferred
Yeah,
consideration construct kick in. But if it
absolutely.
is a payment of bonus and your documents are structured in that manner, then that payment could take place depending on the performance basis which you are being paid the bonus, and the 2518 rule does not come into play there. Of course, each of these have their own tax consequences which should be looked at and considered. But in case of a bonus payment, the deferred consideration is not something that kicks in, and you could be paid bonus depending on your performance and whatever is written in your documents.
No, fair enough. I think that's a very interesting point, and in terms of how we can structure earnouts and any other payouts. So yeah, fully agree and aligned on that.
Okay, I think today we'll stick to only the deferred consideration bit.
Yeah.
Thank you everyone for joining in.
Please join us for the next episode as well, next Friday, and more on the NDI rules. Thank you so much.
Thank you.